A financial dispute resolution hearing, or an FDR for short, is the second main hearing in the financial remedies process. The idea is that both sides go before a judge and they tell the judge what their best arguments are. So the husband will tell the judge his best arguments and the wife will tell the judge her best arguments. And the judge will say, I'm not deciding the case today. I can't make you settle the case. But if I were deciding the case, this is what I'd do. And a judge will usually express a view on the arguments both sides have put forward and tell them what they thought they would do if they were deciding the case. So for example, a judge may say, Mr. and Mrs. Jones, yours was a long marriage. There are 3 children who are now living mostly with Mrs. Jones. I think that if this case came to a final hearing before me, I would be saying that Mrs. Jones ought to have a bit more of the assets because Mrs. Jones is not going to be able to earn as much as Mr. Jones over the next couple of years. And Mr. Jones needs to pay some maintenance to Mrs. Jones, but bearing in mind Mr. Jones needs to make ends meet himself and is already paying quite a bit of child maintenance, it's not going to be a lot. And I think that the amount of maintenance might be this and the amount of time might be this. So that's the purpose of an FDR hearing. And the idea is that after the parties have had the indication from the judge, they come out of court and continue to negotiate in the light of what the judge has said. But of course, how much weight they'll put on what the judge has said will depend upon a couple of things. Firstly, how authoritative was the judge? So is the judge an experienced judge, someone who knows the area of law quite well? If they are, then it's quite likely the parties will put quite a lot of weight on what the judge has said when they're then trying to negotiate. The second point is, does what the judge said tie in with what they themselves were thinking when they came to court? If someone has come to court expecting, for example, a 50-50 division of the assets to be proposed, and the judge suggests something which is a long way away from that, it may be very difficult for them to accept that, and therefore it may be that the judge's indication doesn't take them that far towards reaching agreement. One of the more difficult questions about FDR hearings is how to approach them. There are different styles of negotiation, and essentially they are negotiation exercises. Very often people are hesitant to make the first offer because they think they'll set their bottom line too low. But one of the good points about an FDR is that really you have to have made an offer by the time you go before the judge, and a judge will have expected you to make an offer. The other question is, should you go to court with a so-called bottom line, so a point you're not prepared to go beyond in terms of the negotiations? Bottom lines can be useful because it means that you have to sit down in advance and give serious thought to what you're actually prepared to do to settle the case. On the other hand, they can make you overly rigid. For example, you may go and hear something from the judge which you weren't expecting, and because of your bottom line, you then are not able to negotiate and reach a sensible settlement. So my advice would be to go to court with an idea of what you want to achieve, but not being too set in stone about it.